Welcome to the deep dive. So when you picture a Roman courtroom, maybe you think, serious, formal, all about the letter of the law.
Like scales of justice, solemn judges.
Exactly. But you probably need to adjust that picture. Quite a bit, actually. Because justice in the late Republic and into the early Empire, well, it was less about those dusty statutes.
And much, much more about high-stakes performance. Political theater, really.
That's what we're digging into today, the Roman advocate.
Right. And our sources, well, they paint a fascinating picture. These advocates, they weren't necessarily legal experts in the way we might think of a lawyer today, though they definitely had to know the procedures.
More like masters of rhetoric.
Masters of rhetoric, absolutely. And social climbers, political operators, their success in the forum, in the courts, that was basically the express train right into the heart of Roman power, especially the Senate.
So that's our mission for this deep dive. Really unpack the role, the career, the whole world of the Roman advocate. We're drawing on, scattered clues, but revealing ones. Things about the legal structure, the social scene for the elite.
People like Cicero, obviously, a key figure here.
Definitely. And just the nature of law itself back then. And I think the first thing that jumps out, something our sources make clear right away, is this basic Roman idea that law and political life, the res publica, the state, they weren't really separate things at all.
No, that's fundamental. You can't understand the advocate without grasping that. For an ambitious Roman elite, a legal career wasn't instead of politics. It was politics, just fought in a different arena.
So the forum, the courts, that was the main stage.
It was the primary stage to show off your virtue, your quality, your manliness, your excellence, but also your intellect, your grasp of strategy, everything you needed to govern.
So arguing a case was like a public job interview for running the state.
Pretty much, yeah. A very public audition. You weren't just trying to win for your client, you were building your personal brand, finding powerful friends, showing everyone you were worthy of trust, worthy of power.
So our modern split between law and politics just didn't exist for them.
Almost meaningless in that context. Law was a tool, a mechanism for political competition and advancement.
Okay, so let's follow that path. The advocate climbing the ladder. Status, ambition. It all leads towards politics.
Absolutely. And if you want the poster child for this advocate to politician journey, it has to be Marcus Tullius Cicero, consul in 63 BC. His whole life story is this intersection.
He wasn't just like a lawyer who happened to go into politics.
Not at all. He explicitly connected his work, his legal work, to the state itself, to its structure, its fate.
And didn't he reflect on this later? About how his work only made sense while the Republic stood.
He did, yeah. He wrote that as long as the Commonwealth, the res publica, was governed by those entrusted with it, meaning the Senate, the traditional system, he poured all his energy, all his thought into it.
But then things changed.
Right. When the system started breaking down, when everything fell under, as he put it, one individual's dominion, the move towards emperors, that's when he felt he had to step back. From giving counsel, from active political life, through law.
Which really underscores that connection. His legal career was his political contribution to the Commonwealth, when that political structure changed fundamentally.
His role as an advocate, in that traditional Republican sense, essentially ended. The game had changed.
Okay, but let's think about someone not like Cicero. Maybe a talented young guy, ambitious, but not from a top family.
Yeah.
Why was the courtroom the path for him?
Well, that gets to the heart of Roman social structure. You have to understand how they thought about political unity. It was all rooted in kinship, fundamentally.
Kinship, like family ties.
Exactly. The basic unit was the family, everyone under the oldest living male ancestor. Families grouped into the gens, the house or clan. Houses formed a tribe, and the tribes together made the Commonwealth.
It's really hard for us to wrap our heads around that today,
Right.
A state built so literally on bloodlines.
It is. Ancient societies, generally, they struggle to even imagine a political community that wasn't based on common descent. They saw themselves, quite literally, as descended from the same original ancestors.
So the Senate during the Republic reflected this. It was mostly hereditary.
Very much so. Power and access were concentrated in a few old established families, the curule families, the ones who held the highest magistracies.
Which meant if you were a novus homo, a new man, like Cicero actually, someone whose family hadn't reached the consulship before, getting into that inner circle was a huge deal.
It was seen almost as, well, our sources suggest something like usurpation, a real challenge to the established order, the aristocratic way of things.
So you couldn't just rely on your family name to get you there.
Absolutely not. If you were a novus homo, you had nothing but your own abilities to offer. You desperately needed a stage, a public arena, to prove you had the necessary virtus, the ability, the moral standing, the facies, or loyalty.
And the courtroom was the biggest, most visible stage available.
Crucial, absolutely crucial, especially the big public criminal trials. They were spectacles. It was your chance to show off everything, your rhetorical fireworks, sure, but also your command of Roman values, your strategic thinking, your connections, your dedication to traditional morality.
So a great performance there couldn't be ignored, even if you weren't from the right family.
Exactly. The public, the powerful, they had to take notice. The courtroom was where you proved you had the sheer force of personality, the intellect, the connections, the whole package needed to handle the affairs of state. It was, effectively, a required course on the curriculum for high office.
It sounds less like a court system as we know it and more like, I don't know, a talent show for aspiring politicians.
An organized spectacle, yeah. Designed to filter and promote the next generation of the political elite. That's not far off.
Okay, so this spectacle, this performance, it happened within a specific legal system. And you mentioned that the system itself had problems, big problems.
Huge problems. And those flaws actually made the advocate's performance even more important. Let's look at the stage itself, the formal legal system, the in vinus ordinarium.
Right, you said our sources show people were really unhappy with it, especially later in the Republic and into the early Empire.
They were deeply dissatisfied. The common complaints, excessively formalistic and inflexible. And the delays, notorious. This wasn't just minor grumbling. It points to a real crisis of faith in how justice was delivered.
Let's dig into that excessive formalism. What did that mean in practice? Was there just complicated paperwork?
Oh, much worse than that. Especially in the earlier periods, archaic law was obsessed with procedure over substance. We call it essential formalism.
Dang.
Meaning, in the early civil process, the legis actions, everything depended on using the exact right words, the precise gestures, following a strict, almost religious formula, if you messed up even slightly.
Like say you were suing someone because they cut down your grapevines, but in the formal pleading you accidentally said trees instead of vines.
Your whole case could be thrown out instantly. Regardless of whether the person actually did cut down your vines, the form was paramount, often to an absurd degree.
Wow, so the system itself could feel like a trap.
It absolutely could, especially for ordinary people who hadn't studied these arcane formulas. You basically needed specialized help, which often came from the elite advocates who knew the system's quirks.
And then you add the delays on top of that complexity.
Exactly. The notorious delays. Trials could drag on for months, even years, postponed for religious holidays, bad omens, political maneuvering, you name it. It created massive public frustration.
So if the standard courts, the entitas ordinarium, were slow, incredibly technical, maybe even seemed rigged, where did people go? Did they just give up?
Many started to turn away from those standard public trials, the ordo editiorum publicorum. They looked for an alternative, and that slowness, that inflexibility, it drove them towards a higher power.
The emperor.
The emperor, yes. People began appealing directly to him. They wanted him to step in and apply equita, a sense of fairness, of justice based on conscience, not just rigid rules. They saw him as a higher authority who could cut through the mess.
So the rise of the emperor's justice system wasn't necessarily some grand plan by the emperors to seize legal power.
Less a deliberate power grab initially, and more a response to genuine popular demand. People were desperate. The existing Republican legal institutions felt broken, fragile. They wanted decisive action, fairness, speed, things the old courts weren't providing.
Which tells you a lot about how bad things had gotten.
It really does. It shows the fragility of the established system.
Okay, so given that backdrop, a system bogged down in formalism, moving at a glacial pace, with people losing faith, the advocate's role becomes even clearer. It couldn't just be about knowing the law.
Absolutely not. Quoting the 12 tables wasn't going to cut it. The advocate's real skill, the necessary skill, was to slice through all that legal complexity by crafting a compelling narrative, a story, something honorable, relatable, that spoke to the jury's or the judge's desire for clarity, for decisive action, for moral rightness.
So it pushed rhetoric and emotional appeals to the forefront.
Way to the forefront. The performance, the attack on the opponent's character, the appeal to shared values or prejudices. These often became much more critical than the dry legal points. You had to win the case, yes, but just as importantly, you had to win over the audience, build your political reputation.
And we have a perfect case study for this, right? Cicero, again, prosecuting Verus.
The Verrine orations. They are the absolute classic example of this in action. These speeches, they're not just legal arguments. They are political weapons, public morality plays, statements about who Cicero is and what he stands for.
How did he frame it? Why was he, a prominent Roman senator, prosecuting this governor of Sicily?
He framed it entirely as a matter of duty, officium. He argued he had a bounden duty to defend his Sicilian friends and former hosts against this corrupt governor, Gaius Verus.
Even though Verus was powerful.
Especially because Verus was powerful and connected. Taking him on was risky, but Cicero presented it as a moral necessity. And this is key. An advocate built his reputation, his political capital, on public displays of officium and feeds, loyalty, showing you'd stand up for your friends, for justice, even against powerful enemies.
This also brings up the awkward question of money, doesn't it?
Mm-hmm.
Weren't advocates technically forbidden from getting paid?
Yes. The great paradox. Officially, under the law, you couldn't accept a fee. It upheld the fiction that you were performing a public service, motivated purely by officium.
Come on, they got paid, right?
Well, absolutely. In reality, after the case was won, or sometimes even if it wasn't, the advocate would receive, let's call them gifts. Often very lavish gifts. Huge sums of money, property, favors.
So it maintained the appearance of noble duty while actually being incredibly lucrative.
Precisely. But it also reinforced the class structure. Only someone already wealthy, from the elite, could really afford to spend months or years on a complex case waiting for that eventual gift. It kept the profession largely within the upper class.
Yeah. Okay, back to Verus. The trial itself sounds like a real battle, not just speeches. Cicero talks about Verus messing with evidence.
Oh, completely. It was high-stakes maneuvering. Cicero gives this incredible detail. He goes to Verus's house during the investigation to seal assets, and he sees all these valuable statues and artworks clearly stolen from Sicily, just standing there.
Wow. Brazen.
Totally brazen. But then Verus realizes Cicero has witnesses who saw the stuff and intends to call them. So what does Verus do?
He hides them.
He moves them, gets rid of the evidence Cicero just saw.
Incredible. But Cicero uses that against him, right?
Masterfully. He turns the disappearance itself into proof. He stands up in court and basically asks, okay, Verus, where did those statues go? It's no longer about legal technicalities of theft. It's about the visible, undeniable shame of a guilty man caught trying to cover his tracks. He makes Verus's actions scream guilt.
So the focus shifts hard onto character assassination.
It was the core strategy. Cicero says explicitly, protecting his friends was reason enough to take on Verus's abominable and wicked brutality. He hammers Verus's greed, avaritia, his cruelty, his moral corruption, far more than arguing points of administrative law.
He's playing on the jury's emotions, their sense of outrage.
Directly, and tapping into deep-seated Roman anxieties about moral decay.
How so?
Well, Roman moralists were constantly railing against ruinous expenses, greed, luxury, luxuria. They saw these things as undermining traditional Roman values. So framing the trial as a fight against Verus's corruption and decadence was incredibly powerful. It made Cicero the champion of Roman virtue.
Much more effective politically than just a dry legal argument.
Far more effective. Cicero even twists it further. He basically says to the jury, if you let Verus off, won't it look like you're just waiting for him to bribe you later instead of punishing his greed now? He uses the very fear of corruption to pressure them into convicting.
Wow. So the advocate needed to be a psychologist as much as a speaker.
And a moral performer. The goal wasn't just legal victory, it was political and moral victory. Success came from being a master performer, harnessing the jury's biases, their values, their fears, to win the day and boost your own standing.
So the Verrine orations weren't really about justice for the Sicilians in the end.
I mean, hopefully they got some relief, but for Cicero, it was primarily about proving through this spectacular performance that he was the most capable, most virtuous, most powerful man for the job, specifically the consulship. It worked.
And you mentioned the jury's biases. That wasn't just something advocates exploited. It was actually built into the legal system itself.
Deeply embedded, Roman law was never blind. It explicitly recognized social status and treated people differently based on it.
Right, you talked about this split system.
Yeah.
The honestiores and everyone else.
Exactly. The honestores, literally the more honorable people versus the rest, often called humiliores, the lower people. It was a formal legal distinction.
And who counted as honestiores? Just senators.
It was broader than that. Senators and their families, certainly. Equestrians, the sort of second tier of the aristocracy. Military veterans often got this status. Decurions, who were like local town councilors. Basically the property-owning, politically connected, ruling class.
And what did being an honest juror actually get you in court?
Yeah.
If you committed the same crime as a humiliator, was the punishment really different?
Oh, absolutely. It conferred significant penal privilege. The honnêtes were legally exempt from the harshest, most degrading punishments.
Such as?
Things like being flogged severely in public, sentenced to forced manual labor, condemned to the mines, punishments seen as physically degrading and shameful. Those were generally reserved for the lower classes.
So their status protected their physical bodies, their dignity, even if convicted.
Yes. The idea was partly to maintain the dignity of the ruling order itself. Even if an honest juror committed a capital crime, something technically punishable by death.
They wouldn't necessarily be executed.
Often not. They might instead receive the penalty of exile, being banished from Rome, or relegation to a specific place. It was still a severe punishment, losing your home and status, but it avoided the physical degradation of execution or harsh labor.
That's quite stark. It really shows the court's functioning to uphold the social hierarchy. Punishment itself was stratified.
Absolutely. The law actively reinforced the existing social pyramid. An advocate's job, then, wasn't just about guilt or innocence. If your high-status client was likely to be convicted.
Your job was to make sure they got the honest juror penalty, not the humiliator one.
Exactly. You fought to preserve their standing, minimize the physical consequences, protect their family's property and reputation as much as possible. It was damage control within a status-defined system.
And the status focus wasn't just in criminal law, right? It affected private law, too, especially involving women.
Yes, definitely. Roman law did recognize women as legal persons, which was something, but it also placed significant limits on their autonomy through this institution called tutela, lifelong guardianship.
Even for adult women, they still needed a guardian.
In theory, yes. Even women of full age remained under tutela. The official reason often given was, well, basically sexism. The supposed instability of judgment of the female sex, the infirmita sexis.
But was that strictly enforced?
By the late Republic, it seems it was often becoming more of a formality, especially for wealthy, independent women. They clearly managed their own affairs. Sometimes a guardian, the tutor, could even be forced by a magistrate, the praetor, to grant his formal approval, his auctoritas.
So if it was often just a formality, where did it actually matter? Where did this guardianship really have teeth, legally speaking?
It mattered most in a couple of key areas, very relevant for advocates dealing with property and inheritance disputes. First, a tutor's formal auctoritas was genuinely required for a woman to make a valid will.
Okay, that's significant. And second?
Second, it was required for her to alienate, meaning sell or transfer certain types of really valuable property, specifically something called res mancipi.
Res mancipi, what kind of property was that?
Think the core assets of a traditional Roman estate. Land in Italy, houses on that land, slaves, and the main beasts of burden like oxen and horses used for farming. Basically the foundational wealth.
Why restrict her control over that specific type of property?
Well, the rule often protected the interests of the tutors themselves, who were typically male relatives, like patrons or potential heirs. If the woman died without a will, they might inherit her estate. So they had a vested interest in preventing her from selling off the most valuable parts of it or incurring large debts against it independently.
So an advocate involved in, say, a dispute over a woman's property transaction would have to deal with this, whether she got the proper auctoritas from her guardian.
Precisely. It could become a major legal battleground. Did the guardian approve? Was his approval necessary for this specific transaction? It created this interesting tension. Women could own immense wealth, but their legal power to dispose of the most fundamental parts of that wealth could still be checked by male relatives acting as guardians.
So the advocate might even be arguing for the woman against her own family members who are acting as her tutors.
Absolutely. Navigating those complex family dynamics and legal restrictions around tutela and res mancipi was a key part of handling estate cases.
So whether it's criminal penalties or property rights, the system seems consistently designed to reinforce the existing power structures, the hierarchy of status, and the authority of male heads of household.
That's a fair summary, I think. The law reflected and actively maintained the social order.
Okay, so bringing this all together, this deep dive really paints a vivid picture. The Roman advocate, they weren't just a lawyer. They were a specialist navigating this really complex, volatile mix of law, politics, and social status.
Right, a performer in many ways, whose payment was often disguised, but whose success absolutely depended on that performance. And that success was the essential ticket to political power.
It hinged, as you said, almost entirely on rhetorical skill, on putting on a show, and on framing things in a way that resonated politically and morally within this very formalistic, very class-conscious system, a system that was definitely biased towards the honest yours.
Absolutely. And as we saw with Cicero, that whole performance, that whole career, was deeply tied to the health or perceived health of the Res Publica, the Commonwealth itself.
He felt his professional life ended when the Republic effectively did, when it fell under one individual's dominion.
Which brings us back to that core tension, doesn't it? We've seen the political arena was really the final judge. Advocates won by prioritizing political and rhetorical strategies,
Often by demolishing an opponent's character or playing to the jury's status bias.
often more than by sticking to strict legal precedent.
And this bumps up against the concept that appears in Roman legal writings.
Yeah.
Utilitas rei publicae, the public interest, the utility of the Commonwealth.
Exactly. So here's the final thought, the provocative question, perhaps. If Roman law really was politics by another name, and if the most celebrated advocates built careers by getting favorable outcomes for powerful, wealthy clients, even notoriously corrupt ones like Verres,
What responsibility did those advocates truly have to the actual utilitas, the real well-being of that Commonwealth?
did the duty to your powerful client, your political faction, your own ambition, did that always trump any abstract duty to impartial justice or the broader public good?
And could it be that the courtroom, by functioning primarily as this proving ground for elite ambition and status defense, wasn't the legal system itself, through the very success of its star advocates, actually undermining the res publica it claimed to serve?
Eroding the foundations, perhaps, by constantly prioritizing political wins over maybe less spectacular but more stable legal principles, paving the way for that one individual to take over.
The irony being that the greatest performers in the Republic's legal theater might have helped bring the curtain down on the Republic itself.
It certainly makes you wonder, doesn't it? Does that kind of spectacular rhetoric, essential for political assent in that system, ultimately work against stable governance? Something to think about?